your starting week, we had to have our first session on a Wednesday, and we didn't have a full week, and therefore we are a bit behind, just 1 week behind. Not to confuse your readings. So next week we will enter into the topic of jurisdiction. We haven't discussed jurisdiction yet. Okay, so today we want to continue our discussions from where we left off on Monday. On Monday, we'll learn a little about human rights treaty bodies, about a few core human rights treaties adopted by the United Nations, and that's where treaty bodies become relevant, because treaty bodies are usually discussed in the context of international human rights. We also briefly touch on the idea of regional human rights, and we realize that there are three major regional systems of human rights protection: the European system, the most developed one, of the African system, and the inter-American system of human rights protection. We learned a little about the rationale behind why we need regional systems of human rights protection, going back to the idea of regional values, issues that may be more prevalent in one region and not the other. We talked about European values, and then we talked about some particular practices concerning human rights that were relevant to the African and the American context. So today we want to focus a little more on the European system, because as I said, the European system is the most developed regional system of human rights protection. It's really a model for other instruments of human rights as well, and it generally signifies a very successful model of human rights protection. So we want to learn a little more about the European system today, and maybe a good starting point would be to discuss why Europeans decided to adopt a human rights treaty that was separate from the international system. So this is the year 1950. The world is locked into the dynamics of the Cold War, and that has prevented other states from coming to an agreement about an international system of human rights protection. But a more general question, and a very interesting one to ask, is why Europeans felt the need to have a regional human rights treaty. And who wants to speculate on why they felt such a need? So why Europeans decided to have a human rights treaty? What was the motivating factor? Yes. To counter the hegemony of a rising superpower. That's a novel idea about the human rights system, but a very interesting one to explore. Very, very good and very imaginative. The fear of Holocaust played a major role. So basically, Europeans wanted to keep that self-awareness about the horrors of Holocaust, the idea that if government powers remain unchecked, there may be calamities in store for the European civilization, given that not long before the European Convention, the Europe had witnessed the horrors of Holocaust. Okay, cool, a very good one. the right to abortion and assisted suicide became relevant much later, right? But the idea of European values still resonates with why they undertook such measures. Yes.
Maybe to put it a little cynically, because international systems might benefit more to free colonies, and so the Europeans might have wanted different systems to sort of advantage themselves.
That's not irrelevant. Actually, that had to do with some of what Europeans had in mind. So there was this awareness on the part of some European leaders that these systems could not be extended to colonies, and they wanted to preserve that system for Europeans. Will, you had a comment?
I was just going to say they had a pretty horrible track record.
They didn't have a very good track record of human rights, definitely. Yes? Was the direction that Europe took, again, much later, but still related to the idea of having a common system of legal protection. Many of us somehow automatically assume that human rights had to do with the fear of fascism, but the reality is kind of more nuanced than that. Early 50s was also a period where European leaders were notoriously afraid of communism. And to introduce a system of laws focused on individual liberties would preempt the appeal of communism in Europe. So, unlike what many of us think, actually human rights in Europe somehow had conservative origins. So conservatives, especially in Europe, somehow spearheaded the movement. This is quite against what's happening now, but those old day conservatives were of the view that to protect European values would mean to put more emphasis on individualism. Churchill, for example, was of the idea that European civilization was more advanced and it had to provide means of protecting itself. So Churchill played an instrumental role in adopting the European Convention on Human Rights. Also, French Catholics were very instrumental in adopting the European Convention on Human Rights. The reason was that they wanted to secure the right of religious education for their children. So they feared that with the rise of communist secularism, religious liberties were going to be curtailed in Europe, and this was a way to prevent that, and it was very successful indeed. Another fear that was very common was the possibility of having a mass democracy, a type of majoritarian authoritarianism. So they wanted to also prevent that. In a way, they wanted to protect themselves against the excesses of democracy in a way, or excesses of mass democracy in a way. And you know, that's an important discussion to have, because many of us by default think that conservatives would have been against the idea of having an international system. Today's conservatives definitely make a case against globalism. You know, we all see, so what Trump's speech was about yesterday, you know, and just like he always does, he warned the world against the idea of globalism, but that was not always the case. So early conservatives were somehow in favor of internationalism of a sort, even though it was only confined to Europe. So that's an important thing for us to realize. With that background in mind, I want to see what happened really in the aftermath of the Second World War. 4 pillars of human rights progress were introduced in the wake of the Second World War. First of all, international law in general and human rights law in particular had to be institutionalized. We needed to have different organizations and a diverse set of institutions tasked with guaranteeing human rights. So that's the first pillar of human rights law progress in the wake of the Second World War. The second pillar is judicialization. Human rights is not always about advocacy. It's not always about human rights activism. Human rights is a legal system. And as a legal system, it has to move in the direction of laws, impartiality, and I will elaborate on that a little later. Diversification of remedial practices, giving access to different courts, and embeddedness, which meant that human rights had to be imported in the domestic systems. So what we mean by embeddedness is that human rights have to be integrated within the domestic systems of laws and has to progress and advance from domestic systems first and foremost. And there are different international organizations, one of which is Human Rights Council. I have said very little about Human Rights Council, but because it's a really complicated issue, I'd rather keep Human Rights Council and the discussion about it for a later stage. One note that needs to be added here is that when it comes to treaties, so European Convention on Human Rights is a treaty. We generally have 4 methods of treaty interpretation. There are also other variants of methods of interpretation that have been introduced in recent years, but these 4 methods are usually the main ones and are very, very relevant to the context of human rights as a whole. The first method of, and just to be mindful of the fact that treaties can sometimes be very ambiguous. So the wording of treaties, the phrasing of treaties can give rise to many questions. And judicial authorities, as well as jurists and scholars, need to provide interpretation of those ambiguous terms. So these 4 methods of interpretation are established in order to clarify those ambiguous features in a treaty. So what are those 4 methods? The first approach to interpretation views interpretation as an exercise concerning the object and purpose of treaties. So basically, and we call that the teleological approach. Teleological approach, when facing the question of how to interpret treaties, looks at what the object and purpose of that treaty is, and it tries to interpret the terms and jargons of treaties, the nuances of treaties, in the light of object and purpose of treaties. And as I've said before, object and purposes of treaties are usually specified in the preamble to treaties. For example, the UN Charter has a very famous preamble laying down what the purposes of this organization and the UN Charter are. Okay, so that's the first method of interpretation. So for example, the case of swearing. Remember I discussed that in our previous session, which was about extraditing a German citizen to the US, knowing that he would possibly face death penalty. The European Convention didn't have anything to say about that, but when the European Court was encountered with that question, said, well, the object and purpose of this treaty is obviously to protect individuals. So to expose an individual to death penalty would fly against the object and purpose of the European Convention on Human Rights. So that was an example of the teleological approach employed by the European Court of Human Rights. There's also another form of treaty interpretation, which which, as we will see later, concerns the European practice exclusively, and that's the objective school of interpretation, which means that a treaty needs to be interpreted based on the emerging circumstances, based on emerging issues in a society. So the objective approach looks at how the society's needs, values, system of morals have progressed over time. A great example of this would be LGBTQ rights. So in 1950s, the concept was alien to many legal systems, including Europe. There was no mention of LGBTQ rights in the European Convention on Human Rights. But as we have progressed in time, that concept has been recognized now, and this has been done by dint of introducing an objective system of interpretation which looks at how the society's values have changed and interpret treaties in the light of developing realities on the ground. A third method looks at what the intention of the drafters of a treaty were. So we have a famous term which refers to the drafting history of conventions. It's called travaux préparatoires. Very hard to pronounce, also very hard to spell. We'll talk about that later as well. But travaux préparatoires is the recorded negotiation and drafting history of a treaty. And for some treaties, for example, for the European Convention on Human Rights, we have many different volumes of those negotiations involved. And sometimes as jurists, we go back to those records and say, and contemplate what the intention of treaty drafters were really. And this could help us to come to terms with an interpretation of treaty terms. So that's intention-based interpretation. The most classical example of treaty interpretation looks at the textual meaning of terms employed in a treaty. So a treaty needs to be interpreted according to the ordinary meaning of words and terms used in a treaty. And as we will see, usually human rights bodies use a combination of these methods based on the requirements of a case. So these are 4 methods of interpretation. And as far as those methods go, the European Court of Human Rights uses 3 principles to guide its interpretation. The first important principle is that of subsidiarity, which basically means that before going to an international court or a treaty body, you need to have exhausted all domestic remedies available to you. So this is one condition for admissibility of cases. If the European Court of Human Rights discerns that you have not exhausted the domestic measures available to you, they would usually declare the case inadmissible and they refuse to look into the case. So you have, if you have a complaint against the state, you have to first go to the domestic courts, courts of first instance, appeal courts, and ultimately Supreme Courts. And then after you have exhausted all those remedies and you have not gained an outcome that you think would align with your human rights, you can go to the European Court of Human Rights. So this is a very, very serious principle used at the admissibility stage of the European system. The second principle is margin of appreciation. So this refers to the discretion of states to regulate matters that would concern their domestic arrangements and domestic affairs. Basically, the principle argues that states are in a better position to issue judgments on matters that would pertain to the domestic affairs of states. In order to understand margin of appreciation, we need to understand that there are three categories of rights. The first category we have already discovered is absolute rights. So when it comes to absolute rights, states have very little discretion. States cannot pass laws that would legalize torture, for example, because the right to be free from torture is an absolute right. Or states cannot pass laws that would impose arbitrary death on individuals living under their jurisdiction, because the right to life is an absolute right. The second category of rights we have said very little about is qualified rights. Qualified rights can be balanced based on public order, based on their conflict with other rights. So, for example, the right to freedom of expression is a qualified right. You have freedom of expression so long as your speech does not affect public order or does not create chaos. Or sometimes your freedom of expression may conflict with another person's freedom of religion, and therefore you have to qualify that right. So this is same as the issue of limitations that we have already kind of examined. So that's the second category of rights, and the margin of appreciation really concerns qualified rights. So states are better positioned to pass legislation on, for example, how to limit freedom of speech. And that's where the European Court of Human Rights becomes somehow more deferential to the requirements of domestic laws. Margin of appreciation, well, before I delve into the nuances of margin of appreciation, I just need to say that the third category of rights are limited rights. These are rights that can be derogated from. Okay, there are two ways to construct margin of appreciation, and that's how the European Court of Human Rights has done it. There is wide margin of appreciation, and in these cases, the European court tends to be very differential to the judgments of domestic authorities. Differentials means really respectful to the judgment or discretion of domestic authorities. So that's judicial deference. So when there is wide margin of appreciation and you take a case that concerns a wide construction of margin of appreciation, you have very little chance of winning against the state. Because the European Court tends to be very, very differential in cases concerning wide margin of appreciation. And there is a narrow construction of margin of appreciation. And in cases where states have a narrow margin of appreciation, the European Court is more likely to apply strict scrutiny, which means that in these cases, the European Court of Human Rights becomes somehow more strict about how its provisions are applied in domestic settings. So if you have a case which concerns a narrow margin of appreciation, you have a better chance of winning against a state. Just to add another introductory note here, you can only go to the European Court of Human Rights or any other judicial or quasi-judicial body of human rights only when you are directly influenced by laws. So you have to either be victimized or your rights must have been directly impacted by domestic measures. So you cannot say, you cannot go to the European Court of Human Rights and say that I'm doing this on behalf of all people affected by this legislation. You have to be directly impacted by those measures yourself. Also, you cannot raise cases against private bodies. So, for example, in the context of Canadian law, human rights cases, if taken to an international body, concern measures taken by federal institutions. You cannot raise a case in international bodies against a corporation or against any other actor that is of private nature. So the only adversaries in human rights cases must be state and public institutions. There is increasing realization in human rights about the measures undertaken by companies that can impact human rights. We have an emerging field called business and human rights, but we are yet to see a cooperation being brought before an international body. In domestic settings, you can go to courts and say that what this company is doing goes against, for example, the Canadian Charter of Rights and Freedoms. But in an international setting, that cannot be the case. Yes.
Yeah, I was just kind of going to ask. So, in cases where there's a private company or corporation like plundering the resources of a country or causing pollution that impacts someone, and the courts in that country are maybe paid by that corporation or unreceptive to that messaging, that person would then have to go to, I guess, the UN or a higher court, and they'd have to challenge the government and make the case that they are rigging the courts.
Exactly. So in those cases, you have to prove that it has been the government failing to protect rights. And it's not uncommon that governments will be held accountable for actions of private institutions or organizations if the government has failed to take measures countering possible cases of human rights violations. But the responsibility of governments and states in such situations is indirect. So one way to uphold human rights when violated by private entities is to look whether governments have taken due diligence in countering human rights violations. So this is also another technical term. Due diligence, measures necessary to fulfill human rights or measures necessary to respect and protect human rights. And this could be confusing at times. So the European Court of Human Rights and the International Covenant on Civil and Political Rights mostly contain rights that we consider as negative liberties. And as we learn, when it comes to negative liberties, states must refrain from interfering with rights. But their obligation doesn't stop there. These instruments also imply that states must refrain from interference with human rights, but also they must take measures to ensure these rights are respected and protected. So due diligence implies that the states must take positive measures to fulfill and respect human rights, or to respect and protect human rights. Okay, so that was the second principle guiding European Court of Human Rights interpretation. The third element of interpretation used by the European Court of Human Rights plays into what we discussed just a minute ago. So we learned that there is a method of interpretation that we identify as objective. An objective interpretation basically means that obligations need to be interpreted in the wake of developing circumstances in societies, emerging values, changing conditions. And the European Court of Human Rights refers to that method of interpretation as living instrument. So living instrument basically means that the European Court of Human Rights, the European Convention on Human Rights text is not frozen in time. It has to be construed based on the living conditions in different societies. So as I said, transgender rights, for example, they were not recognized in the 1950s. They were not recognized as such in the 1960s. But starting from 1990s, you see a change in how the European Court of Human Rights goes about these rights. And we're going to see some examples of how the European Court really has employed these elements of interpretation. So this is a case that I regard as one of the most controversial cases in the entire history of the European Court of Human Rights. It is called the case of Winter et al. Versus United Kingdom. And these pictures that you see here belong to some creepy serial killers that were the applicants in this case. So this case concerned 3 individuals, all of whom were convicted of several counts of murders. One of them was a serial killer who had uh, raped and killed at least 4 males in the UK in mid 1990s. And all of these individuals had been sentenced to life imprisonment without the possibility of bailing out. So they could not be bailed, which meant that actually they were condemned to rot in prison. They would remain in prison until they died. And they said that we need to remain hopeful about our redemption, and there may be some chances for us. So why not taking our chances in the European Court of Human Rights? And basically these three individuals go to the European Court of Human Rights and say that our imprisonment without the possibility of release or without the possibility of being bailed out violates our rights. And now the European Court of Human Rights had to respond whether imprisonment without the possibility of release or review at a later stage would constitute a violation of human rights as recognized in the European Convention on Human Rights. Before telling you what the judgment was, how would you rule in this case? Would you say that this would violate their human rights to be in prison without the possibility of release? Yes.
I would say if like the law they were abiding by stated that if they committed like a crime, if they did like murder on multiple accounts, that that was a possible punishment, that it wouldn't be a violation of their rights because if that was within the law, then like that's within the country that they reside in. They would have to abide by that. They committed a crime with that law being in existence before they committed the act. So it's not a violation if they chose to pursue that given the law.
So you're saying because these standards are already specified in the domestic laws, it wouldn't make sense for us to introduce later reforms and would let these individuals benefit those reforms. Okay, not a bad argument. Yes.
I think it's more like it's not valid at all, most likely, because like it's a limited right, ultimately, right? So like you need to respect the domestic law, same as what she said.
Cool. Thank you.
Just have a question. What human rights were they claiming were being violated?
They raised their case under Article 3, to the best of my knowledge. Article 3 of the European Convention on Human Rights concerns torture and degrading treatment. So basically they were saying that our life imprisonment really is a form of torture, is a form of degrading treatment, because our dignity requires that we will be given some possibility of release. We want to remain hopeful that we can be redeemed, right? And I don't know why they took their case so seriously, knowing that even if their right to release was recognized, it really wouldn't mean that they would be released, right? But they still were adamant about it, and maybe that gave them something to do in prison, keep them occupied. So that's what they did. Any other intake? Yes.
I would look at the precedents, like have there been prior convictions that have led to a different ruling? Because if we're looking at like what the current precedents of the country are, like if there's some previous person that tried this and said that, you know what, this is a violation of my rights, then we would have to take that into consideration based on the ruling that was presented.
So you are of the view that their conduct must be taken into account, and if they show a type of behavior that's receptive to.
No.
Okay, yeah.
I'm just saying that when they presented this, like if from at the human rights, I wonder if there've ever been any precedents under their domestic laws where
where somebody else has presented a case like this and had a different, like kind of ruling in the favor of the defendant at the time. So that's what, but no, I think that they should remain where they are.
Okay, they belong to jail. All right. I mean, they went initially to the UK courts and they argued their case in the UK courts, and the UK courts did not agree with them. That's why they went to the European Court of Human Rights.
Wouldn't like any form of jail time be considered degrading treatment? Like, where do you draw the line between human right and like, okay, we need to have jails?
Yeah, I mean, some people say that the very idea of prison flies against human dignity. So to keep individuals in detention is an undignified act in and of itself. But there are forms of imprisonment that definitely can be considered as torturous or degrading. For example, solitary confinement is considered as a form of torture. If you keep a person in solitary confinement for too long, mostly for longer than 24, 48 hours, that can be considered as constituting torture. No, they were with other dangerous prisons, you know. And the UK prisons, I had the opportunity to go there when I was a student in the UK. They could be, you know, very high standard. People had TV and like a good cell and generally good interaction with other prisoners. So it's not that bad either. I mean, sometimes you wonder, you know. Okay.
I feel like for me, I'm leaning towards like public interest. If you don't accidentally kill multiple people, I feel like in the case of like where it was self-defense or involuntary manslaughter, the law does count for that. But if all three of them have been convicted of killing multiple people, I feel like you could cite like in the case of public interest, we can't actually release you because there's no promise that you wouldn't do it again, especially considering one of them is a serial killer.
Absolutely. I mean, and they were notorious murderers. You know, they knew that they wouldn't be released, as I said, but they wanted to have that dim light of hope, maybe for future prisoners. Yes.
Oh, I was also curious how long they've been in jail before they asked for like this parole thing. Like, how long have they been in jail before they asked?
Because there were three individuals, they'd been detained in different periods of time. So one of them in mid-90s, one of them in early 90s, and one of them, I think, late 90s. This was adjudicated in 2013, so I guess that at least two of them had been there for at least 2 decades. All right, this, as I said, is one of the most controversial cases decided by the European Court of Human Rights, and the European Court ruled that these individuals were entitled to have their imprisonment reviewed for the purposes of bailing, giving them bail. This doesn't mean that they can be released or they must be released. This just means that their imprisonment, their life imprisonment, must be reviewed every now and then. Usually, especially in the UK, what they do is that they review, even when, like sex offenders, even when they complete their sentence in the UK, sometimes they are not released because a review board will determine that they still pose a threat to public, and they will remain in what is called preventive detention for even some years after they have completed their prison terms. A very contentious practice in the UK law. Though in recent years there has been this movement in Canada and Western Europe for eradicating prison. The argument has been prisons are not really preventive, and this whole sentence of imprisonment is against human dignity. And this has, unfortunately, for better or worse, let's say, has resulted into many offenders not receiving substantial prison terms, even when their crimes have been regarded as serious and very dangerous. So sometimes, you know, courts in Finland, in Canada, in Norway, they tend to give very lenient sentences to individuals, and sometimes a more philosophical discussion is raised as to how preventive imprisonment as a sentence can be. Just to give you an idea, there was extensive research on, there has been many different research on these issue. One of the most extensive ones came out last year, and it said, basically, it concluded that imprisonment can be very effective when it comes to decapacitation. So decapacitation means to deprive an offender of the opportunity to commit or to offend. So prison as a sentence can be very effective in terms of decapacitation. But in terms of prevention and deterrence, really not that preventive, right? Individuals who commit crimes know that their crime may result in substantial prison terms, and still they commit them. But, well, to keep them in detention is not bad policy, especially if it's proven that the individual is a danger to the society. Sometimes I don't agree with my fellow law experts when they make the case for eradicating prison altogether as a sentence, right? But, you can introduce many different reforms in how you go about keeping individuals in detention. We have restorative sentences. You can give individuals means of restoration when they serve their sentence in a prison, or you can have retributive sentencing where individuals are kept in harsh conditions. Canada's prisons are amongst the worst ones in the West, at least. Not high standards of treatment in Canadian prisons. There's not a lot of money, public resources that go to reforming sentencing in Canada. Yes.
Okay, so I have a two-part question. One, if they are, okay, what type of system did the UK have? Like, is it that, oh, sorry, two things, my mind is, did the human rights, was their ruling, like, was one reason for their ruling the fact that if the cases were never reviewed, then there's no chance that they can have like better conditions in jail? Like in Canada, there's like maximum, right? And without your case being reviewed or your file being reviewed, there's no chance that you can go to like minimum or like medium security, right? So was that a factor in the ruling? Because if their case is never reviewed, then they would just remain at the maximum, and then that would be like, they would have more grounds for it to be called like torture or harsh conditions.
Well, I have to here add another note, which is that the European Court of Human Rights did not say that the conditions of these prison sentencing would constitute torture. So it did not agree with the argument made on that front. However, it said that prisoners are entitled to a right which it identified as the right to hope. So this is why I chose this case, because the right to hope is not something that had been mentioned in the European Court of in the European Convention on Human Rights, and still the European Court introduced that concept, and it did so based on its reading of the European Convention on Human Rights as a living instrument. So it said that, every individual is entitled to the right to hope. And the right to hope really means that you can hold on to the hope of release, even though that may not be a possibility. So extremely philosophical in a way, right? What is the relationship between our subjective understanding of hope and how the society's obligations must be upheld in that regard. It really did not look into the condition under which these individuals were kept. It also did not look into the question of maximum and minimum terms for sentencing. But it introduced this new concept of the right to hope based on how it interprets the European Convention on Human Rights. So when this case was adjudicated, it gave rise to a very persistent controversy in the UK. The controversy in the UK has always been, ever since 1998, where the UK passed a piece of legislation called the UK Human Rights Act of 1998. The controversy revolves around whether domestic systems need to subject themselves to superior orders by international bodies. So many millions of people in the UK are increasingly of the view that the European Court of Human Rights is really encroaching upon the UK sovereignty. And when this dispute was settled by the European Court, it gave rise to that old argument on the part of many people, usually on the right, that the European Court is doing something that relates exclusively to the domestic domain of states. This international form of sovereignty is not really in the best interest of the UK people. And as the march last week showed in the UK, for better or worse, millions of people feel that way. That's not to say that the European Court has done a bad job or a good job, but there is that debate, and that debate is very serious in some countries of the European, of the members of the European Council, including UK. Moving on, let's look at another case where the European Court does the opposite, and instead of imposing a norm on domestic jurisdictions, it does agree with what has happened in the domestic settings of a state. So this is the case of Handyside versus UK. It's a very old case and one of the most famous ones. 1976. Handyside was a school teacher who wanted to publish a book about teenagers' lives, and some parts of the book were really obscene. So on one chapter of the book, he advocates drug use for teenagers, and it says to teenagers, the book says, if you want to take drugs, don't go and do heroin. Cannabis is probably a better idea, and if you want to do it, do it this way or that way. This was in the 70s, and the UK decided not to publish the book, and the book was banned. So the writer was very offended by that ruling, by that decision, and he goes to the European Court of Human Rights and says, this is against my freedom of expression, this is against my freedom of speech. This book needs to be published. It's filled with original ideas. And the European Court says in this case that because this is a domestic affair relating to the public order and domestic morals of a state, it needs to show margin of appreciation in a wide and broader sense to the UK authorities. So the argument here was that the UK laws were better positioned to deal with this question. This is the first time that the European Court of Human Rights introduced the concept of margin of appreciation. So the concept of margin of appreciation was really configured in the Handyside case. And because the right to freedom of speech is a qualified right, therefore, the European Court used a wide construction of margin of appreciation in this case. So this is how margin of appreciation was used, but also subsidiarity, arguing that the UK courts had sufficiently dealt with the question, and the European Court of Human Rights had no grounds to proceed with the case. Another case very similar, the Sunday Times versus UK. The Sunday Times wanted to publish a piece on an unfortunate incident in the UK called thalamoid incident, if I'm not mistaken, and was ordered to censor the opinion piece. It goes to the European Court, and again, because the right to freedom of speech is a qualified right, the European Court uses a wide construction of margin of appreciation. It agrees with the UK authorities to encroach upon the issue. This is the case of SAS versus France. We have already discussed this case. This is when the applicant wanted to wear full face veil, and the European Court of Human Rights again used the concept of margin of appreciation to reject the case and say that the French authorities were in a better position to pass laws that were in line with their culture or with their sense of morality as they wanted to uphold in such cases. So the doctrine of margin of appreciation really gives the European Court some ground or some room of flexibility to take into consideration the domestic context. So in the context of French laws, ever since the French Revolution, secularism has been very pervasive, and therefore the European Court of Human Rights saw it as fit to reinforce that domestic conception. Okay, I think it's not a bad idea for us to take a look at, hopefully if this works and does not decide to freeze again, to watch a short video about the European Court of Human Rights, how it operates, and what are some of the procedural matters pertaining to the European Court of Human Rights. Okay. Yes.
Quelque part, une sonne d'alerte pour les opinions nationales menacées de cette grande grève progressive. Une conscience quelque part qui leur montre le péril d'une juridiction internationale au sein du Conseil de l'Europe. Un système de contrôle et garantie, ce pourrait être cette conscience dont nous avons tous besoin.
Each year, tens of thousands of people who consider that their fundamental rights have been breached turn to the European Court of Human Rights. What is this court, which for over half a century has allowed individuals to have states held to account and whose decisions may ultimately affect our everyday lives? It was in 1949, in the aftermath of the Second World War, that a number of countries joined forces to set up the Council of Europe in order to promote human rights, democracy, and the rule of law across Europe. They adopted the European Convention on Human Rights, setting up a system that was unique at that time, including a binding supervisory mechanism. That was how the court came into being in 1959, reflecting the member states' desire never again to experience the atrocities committed in the mid-20th century. 12 states signed up initially. Now there are almost 50 of them. The court is based in Strasbourg, in the Human Rights Building. It is composed of one judge for each member state of the Council of Europe. The judges, who are elected by the Parliamentary Assembly of the Council of Europe, are fully independent and do not represent any national interests. In dealing with cases, the judges are assisted by the registry, which employs qualified staff from all the member states. The court receives hundreds of letters and phone calls every day. When applications arrive at the court, they are sorted and then dispatched to one of the units of the registry which prepare the files for the judges. All the decisions are taken by the judges, sitting as a single judge formation, a 3-judge committee, a 7-judge chamber, or a grand chamber of 17 judges for the most important cases. The procedure is conducted in writing, but in a very few cases, the court also holds public hearings, all of which are filmed and can be viewed via webcast. The court receives a huge number of applications every year. However, the vast majority of them are rejected at the admissibility stage because the criteria for applying to the court have not been met. For example, because the applicants have not first raised their case before the national courts. For that reason, the court delivers judgment on the merits in only a small proportion of the cases brought before it. It then rules on whether or not there has been a violation of the Convention, and it may award financial compensation. Since it was first set up, the court has completed the examination of hundreds of thousands of cases. This is hardly surprising, given that the number of individuals covered by the system totals around 820 million people. That is the number of potential applicants living in the countries which have undertaken to comply with the Convention. In reality, however, there are even more potential applicants. Non-Europeans, whether they are refugees or other individuals who happen to be within the jurisdiction of a member state, are also protected. For instance, the court found a violation of the Convention by Italy following the forced return of Somalians and Eritreans to Libya, from where they had originally set out by boat for Europe. The court held that they would be at risk of ill treatment if they were repatriated. In exceptional cases, the scope of the Convention can also extend beyond Europe's borders. The court found the United Kingdom to be in breach of the Convention following the deaths of civilians in Iraq during security operations carried out by British forces. The court held that, as an occupying power responsible for maintaining security in the region concerned, the United Kingdom should have conducted an investigation into civilian deaths in which British soldiers were involved. A state can thus be held responsible for events occurring outside its territory. But states can also be held accountable for acts committed within their jurisdiction by another state, if they were aware of them. This was the case with the former Yugoslav Republic of Macedonia, which was found to be in breach of the Convention because a person suspected of terrorism was tortured while on that state's territory. The torture had been committed by CIA agents, but in the presence of officials of the state concerned.
Just to add one note, non-European states cannot appear as defendants in the European Court of Human Rights. That's why you couldn't have a case against the US, but in this case, Macedonian authorities had failed to respect the obligations on the European Court of Human Rights, European Convention on Human Rights, and they were held responsible.
Under the Convention, the most fundamental is the right to life, and the death penalty is no longer applied in any member state of the Council of Europe. Some cases concern the treatment to which the population is subjected in conflict zones. Other cases relate to the state's failure to protect individuals. The court found a violation by Turkey for an infringement of the right to life and discrimination against women. The case concerned physical assaults carried out repeatedly by a man on his wife and his mother-in-law. The husband later killed his mother-in-law. The court has also had to rule on the sensitive issue of the end of life. In a case against France, it held that there would not be a violation of the Convention in the event of implementation of a decision by the French courts to authorize the withdrawal of artificial nutrition and hydration from a person in a vegetative state. Another fundamental right is the prohibition of torture and inhuman or degrading treatment. Greece was found to be responsible for the torture of an unlawful migrant from Turkey, whose boat was stopped by Greek Coast Guard officials while he was attempting to reach Italy. The man had then been beaten and sexually assaulted by one of the officials. In the numerous other cases brought against various countries, the court has identified problems with overcrowding in prisons and inhuman and degrading conditions of detention. But most of the cases coming before the court concern the right to a fair hearing, and especially the length of domestic proceedings. The court has received thousands of applications from individuals who in some cases have waited more than 20 years for a final judgment in their own country. There are also very many cases concerning the failure to execute final judicial decisions. For example, Anatoly Burdov, who worked on the Chernobyl site following the nuclear disaster, had to wait several years before the Russian authorities paid him the compensation awarded by the domestic courts for his health problems. The court in Strasbourg held that a state could not cite budget shortages as a reason for not executing a judicial decision. The rights and freedoms contained in the Convention are set out in general terms, and the court has to interpret them in the context of today's society, in order to avoid the Convention becoming a document that is out of touch with contemporary issues. For instance, the court has delivered judgments in several cases concerning discrimination against homosexuals, whether in the context of the criminalization of homosexuality, the ban on homosexuals in the armed forces, or the organization of gay pride marches, and with regard to civil partnerships. It has also had to rule on environmental issues. In a case which led to a finding against Italy, and subsequently to the closure of a hazardous industrial plant, the court found that the authorities had not informed people living near the plant about the risks and the procedure to follow in the event of an accident, even though there had already been one explosion and numerous cases of poisoning. The court has also ruled on issues that were unimaginable when the Convention was adopted, for example in cases concerning new technology. In one case, it found that Turkey had breached the Convention by blocking access to the entire Google site's internet hosting service. The court held that restricting access to the internet in this way was a breach of freedom of expression.
Okay, so unfortunately I have to cut it short because I also want to show you another video on the European Convention, on the European Court of Human Rights. If I find it here. I just have to say that on average, it takes 6 years for the European Court of Human Rights to pass a judgment on any case. It's because the European Court itself is a multi-layered system, as you learned from the last video. It has a committee. First of all, it has a one-judge stage in which a judge decides on the admissibility of a case. Then it has a committee composed of 3 judges. Then it has a chamber composed of 7 judges, and it has a grand chamber composed of 17 judges. So it's a quite a laborious process. Also, it has quite a backlog of cases because there's 47 countries that are members of the Council of Europe. I think Russia was expelled, so 46 countries now. And there's quite a backlog there, and that has slowed down the process. This video is about the debate on sovereignty of states on one hand, and the super national mechanisms as offered by bodies such as the European Court of Human Rights. As I said, there is an emerging, a very strong pessimism in the UK and the rest of Europe towards the European Court of Human Rights. And this video somehow meant to respond to those criticisms, although it wasn't very successful. So let's see what the argument there is. And it's quite a short video too.
Before we start, I want to be absolutely clear about one thing. We are here to serve the British people, not the whims of some European imperialist state. We're a proud nation, and no bureaucrat of Brussels can tell us what to do. We are a democracy, not some perverse, genuflecting mouse puppet on a European finger. The idea of that makes me physically sick. They took our sovereignty, our dignity, the very essence of our Britishness. And what has the European Convention of Human Rights ever done for us in return?
Or the right to a fair trial.
What?
Right to a fair trial.
Well, that's true, I suppose.
The right to privacy?
Well, yes, all right. I grant you, fair trials and privacy are two things the European Convention of Human Rights has given us. But
What about freedom from torture and degrading treatment?
Freedom of religion.
Freedom of expression?
Freedom from discrimination.
Oh, how about freedom from slavery?
yes, of course, freedom from slavery goes without saying. But
Protecting victims of domestic violence.
okay, but apart from the right to a fair trial, the right to privacy, freedom of religion, freedom of expression, freedom from discrimination, freedom from slavery, and freedom from torture, and degrading treatment, and protecting victims of domestic violence, but apart from these, what has the European Convention on Human Rights ever done for us?
Peace in Northern Ireland?
What?
Well, I guess the Good Friday Agreement depends on the European Convention of Human Rights. So without it, we'd have to make a peace all over again. And what a palaver that would be. No, thank you.
Look, I'm not against human rights, of course not. But I say we don't need lectures from the frogs and the crowds. This is Britain, the land of Magna Carta. We invented human rights, for God's sake. We should be writing our own Bill of Rights and foisting it on the Europeans. Let's see how they like it then.
We've already done that.
What?
After we won the war, British legal experts did draft a Bill of Human Rights to help Europe sort itself out, protect people from abuses of state power, that kind of thing.
Eh?
Oh, yeah.
You sure?
Oh, yeah.
Ah. Well, that's good. What's it called?
The European Convention on Human Rights.
Oh, fuck off!
It's quite a nice and interesting video, though that's a very serious debate. And to some extent, those arguing against the European Court of Human Rights or the excesses of the European Court of Human Rights Not always, but there is some logic to that argument. The logic is that the European Court of Human Rights was established on the premise of judicialization, not judicial activism. And what it has grown to be is more of an advocacy institution, and there is always some risks in that, right? So as a judge, you need to be careful to draw the line. You are not an activist, you are a judge, you are a jurist, right? It's the job of activists to project an idealistic, an ambitious vision of human rights. But as a judge, you need to be focused on what the pre-existing laws are. Sometimes it becomes very hard to draw the line. And one of the strongest criticisms recently directed against the European Court of Human Rights is that it has fallen for the trap of judicial activism. Okay? To some extent, in some cases, that's true, but not generally. But we need to be mindful of the fact that arguments on the other side have some merits. They are not devoid of logic. And you have to understand where they are coming from too. All right, I think we'll leave it here for today. Thank you all. Next Monday, we're going to have a quiz. So try to review the materials beforehand. And we're going to take a quiz next Monday.